Declaration on Criminal Justice Reform include potentially reducing case backlogs and expediting the delivery of justice. While the Declaration acknowledges that jury trials remain the dominant mode of proceeding, it suggests that judge-alone trials should be considered where appropriate. This move, being led in the Caribbean, is being recognized throughout the world. A government-commissioned review by Sir Brian Levison warns that England and Wales Crown Courts are facing collapse under a record backlog of 75,000 cases, some delayed until 2029, and recommends removing the right to jury trials, replacing them with judge-led trials, and incentivizing early guilty pleas. So we're not just doing it in the Caribbean. What we're doing in the Caribbean is being recognized and adopted internationally. Now, the concept of judge-alone trials, Madam Deputy Speaker, is not new. Many Commonwealth jurisdictions, including Antigua and Barbuda, Trinidad and Tobago, Jamaica, Belize, Turks and Caicos, the Cayman Islands, New Zealand, and Australia, have successfully implemented such legislation. These countries have recognized the need for a more streamlined judicial process, particularly in cases where jury tampering or the safety of jurors is a concern. Madam Speaker and Madam Deputy Speaker, I want our people to know, what we are doing in St. Kitts and Nevis in justice reform is actually revolutionary. The major improvements we have made to our justice system is reverberating throughout the Caribbean and further afield. So I'm very pleased to inform the people of our country that I have been invited in my role as Minister of Justice and Legal Affairs and Attorney General by the President of the Caribbean Court of Justice to deliver the keynote address on criminal justice reform at this year's 8th Biennial Conference, which is titled the CCJ at 20, Reflections on Caribbean Jurisprudence. Madam Deputy Speaker, we are doing something right in St. Kitts and Nevis. We're doing something right in St. Kitts and Nevis, Madam Deputy Speaker. Persons are noticing. But there will always be persons who have ill intent, who will turn a blind eye to the good job that is being done. But nevertheless, at some point, they will eventually come around. So I've heard some criticism of the judge-alone trials. There seems to be two persons in the entire federation who don't like them. But some people talk just for talking's sake, and they try to ignore the facts. The fact is, the vast majority of criminal matters tried in St. Kitts and Nevis are tried by judge alone in the magistrate's court. These matters are not just the summary criminal matters. Hundreds of serious firearm and drug offenses over the past 4 decades in St. Kitts and Nevis have been tried before judge alone in magistrate. The jury system does not factor in the magistrate's court, so we are already accustomed to judge-alone trials in the most active of our courts. And as I said when we debated the original bill, Madam Deputy Speaker, only approximately 3 out of every 10 cases are likely to be impacted by the judge-alone trials bill and tried by judge alone. In other words, 7 out of every 10 cases in the High Court, criminal, are likely to be before a jury. And what we've seen in the first 10 months is that less than 10% have actually been trials by judge alone. So the original act, Madam Deputy Speaker, was a forward-thinking piece of legislation, and it aligns with the Sustainable Island State agenda. It promotes efficiency, fairness, equity in our criminal justice system, and ensures that all accused persons receive a fair trial within a reasonable time. And I want to reiterate, Madam Deputy Speaker, a murder trial that is ongoing for weeks turning into months would have been aborted, meaning you have to start from scratch. You have to contact jurors. You have to get all the evidence gathered. You have to recalibrate. And more than, I believe it's almost up to 3 months now, of judicial time would have been wasted if the Judge-Alone Trials Act was not in force. We have to protect our jurors in high-risk cases. The Justice Interference Prevention Act is a deterrent, but the Judge-Alone Trial Act contemplates that in certain high-risk cases involving gang elements, persons that can be influenced, those are judge alone so that jurors cannot be intimidated and contacted. Madam Deputy Speaker, I was told of a case where a juror's cousin was being driven around Fort Lands, around the cenotaph, repeatedly in a car with a co-gang member of a person who was before the court. Those are the reasons why we even brought judge-alone trials in the first place. We cannot afford to have those types of intimidation techniques in a very small society. If that were to take root, there would be no justice. There's a new paradigm in justice in the Federation. It is being acknowledged by the courts and all of the players in the justice space. We are working together. We have a justice committee that meets regularly to figure out how we can ensure that persons from the time they are charged to the time their matter is dealt with comes down to less than 18 months. In some jurisdictions in the Caribbean, the average time for a matter after charge to reach conclusion is 10 years. We cannot, based on the terms of our Constitution, allow a person to be waiting in limbo for multiple years. And that is why we are taking innovative steps, partnering with others, learning from best practices, and implementing these types of measures in our jurisdiction. Anybody that tells you otherwise does not care about this federation. Anybody who tells you otherwise does not care about anybody accused of a crime. This is the movement that the international community is taking, because we simply cannot have people waiting for justice for years and years and years, some of them being on remand in prison, waiting for their day in court. So whilst we are approaching this from a novel standpoint, there are many others on board. And the Needham's Point Declaration on Criminal Justice that was established just less than 2 years ago, where all of the leaders in the justice system, DPPs, judges, lawyers, came together in a room at Needham's Point in Barbados and said, these are the things we have to do. We are taking that blueprint and we are implementing it in St. Kitts and Nevis, and we are seeing the fruits of that labor, Madam Deputy Speaker. Now, if you'll allow me to just set out the key amendments in the bill. Section 4. This is really the heart of the original Act, which mandates judge-alone trials for certain indictable offenses listed in the schedule. The amendment clarifies and strengthens the procedure. It removes the procedural ambiguities that created confusion about when judicial discretion could override the mandatory nature of judge-alone trials for specific offenses. Under this amendment, if a person is indicted for one or more scheduled offenses, the trial must proceed without a jury. However, the amendment introduces a limited prosecutorial discretion to apply for a joinder of non-scheduled offenses to the same indictment, but only where those counts arise from the same facts or form a series of similar character. The judge, upon hearing both sides, must decide whether the interest of justice warrants that the entire matter be tried without a jury. Importantly, to safeguard finality and avoid procedural abuse, no appeal shall lie against a judge's decision to allow or refuse such a joinder or judge-alone trial under this section. Section 5 is comprehensively restructured. It now allows either the prosecution. I was asked this question at the Prime Minister's press conference earlier this week. The amended Section 5 allows either the prosecution or the defense to apply for a judge-alone trial in cases that are not mandatory, meaning not listed in the schedule, based on a wide and well-defined list of factors. These factors are risk of jury tampering or intimidation, complexity and length of the trial, application which can be made either by the prosecution or the accused. The amendment also harmonizes our law with jurisdictions which have had judge alone for a while, Trinidad and Tobago and Jamaica, where similar factors guide the exercise of judicial discretion. Again, no appeal lies from the judge's decision to grant or deny such an application. The provision was preserved to protect the expeditious administration of justice and to avoid frivolous interlocutory delays. Now, one of the most important additions in this bill, Madam Deputy Speaker, is two fundamental safeguards. First, it empowers judges to decline to conduct a trial without a jury, even if both parties apply for one, where the judge believes it would compromise fairness, promote injustice, or be contrary to the public interest. This ensures that judicial discretion is never mechanical or automatic. It is always tied to an overarching duty to protect the integrity of the proceedings. Second, it codifies the grounds for judicial recusal, such as actual or perceived bias, conflict of interest, or prior expression of prejudicial views. And where recusal or refusal occurs, the judge must provide written reasons on record, ensuring accountability and transparency. I'll give you an example, Madam Deputy Speaker. If a judge in a previous trial found that a particular police officer did not provide credible evidence, and the judge had a bias and felt that that police officer could not give credible evidence, then the judge could recuse him or herself from another matter because of that potential bias they may have had from an experience in the past. The same thing can happen if there's a witness in two different matters and the judge does not feel that they can be unbiased in making a determination. They can recuse themselves and another judge can step in and deal with the matter. Now, this particular section directly addresses concerns raised by legal practitioners about the need to balance efficiency and fairness and to reinforce public confidence in the judiciary. The last amendment, Madam Deputy Speaker, streamlines the schedule of offenses for which trials must proceed without a jury. With the addition of the new Section 5, which gives the prosecution and the defense an opportunity to apply, there is no need to have as many mandatory judge-alone trial offenses in the schedule. So the amendment removes many of those technical offenses because each party now has the right to apply for the judge alone. But the new schedule focuses on the most serious indictable offenses that pose threat to public safety and national security, are linked to organized crime, corruption, gang activity, or terrorism, involves risk of witness intimidation or public prejudice. And we have also added in the schedule attempted murder and shooting with intent, which are offenses that were amended last year when we amended the Offenses Against the Person Act. This ensures that trials for crimes involving firearms and high levels of violence, often committed in gang contexts, proceed our deep of legislation is perfect. But when you see it in practice, you see the flaws, you bring it back, and you try to get it better and better each time. And that is why we're here. We want this to be a clear, fair, and accountable process. And at the end of the day, Madam Deputy Speaker, I believe that this amendment complies significantly with the rule of law, and it fortifies our efforts to build a resilient, modern, and sustainable justice system. I therefore commend it to this House for support. And Madam Deputy Speaker, I want to end on this point. I want our people, whoever is listening, to know St. Kitts and Nevis is known in the Caribbean as being the leader in criminal justice reform. This is not by accident. This is through hard work. This is through research. This is through detail. This is through collaboration. And this is all part of the bigger picture that the member for St. Christopher 8 has said. It takes a whole of society approach, to deal with criminality and violence, means that the justice system must also be on board. of our.
I'll start by saying, Madam Speaker, that I had some concerns with the initial bill, which was passed in this House sometime, I think it could have been in September of last year. And the reason I had that particular constitutional bill, which was passed in this House sometime, I think it could have been in September of last year. And the reason I had that particular concern, Madam Speaker, is that, to the best of my knowledge, the initial bill only allowed for the prosecution to be able to make the application for the judge alone trial. I recognize that in Section 5, number 3 amendment of Section 5, that the accused can now make that particular application. And I want to commend the mover of the bill in that particular respect, because I honestly felt that it was unfair for the prosecution only to be able to make it was on, I don't know how we got off. But when you took into consideration the fact that with regard to this particular piece of legislation, you do not have the right at this particular point in time to make an appeal in terms of the decision taken by the judge as to whether or not to grant the application to have the trial being heard by the judge only. Indeed, in terms of trials by judges alone, the statistics, the research would indicate a vast number of differences within various jurisdictions as to the outcome. We're still relatively early in terms of the usage of this particular piece of legislation, and I suppose that in time one will be able to analyze the full effects of it. Some of the indicates that in some jurisdictions it has actually enabled more accusers to be acquitted, and there are various reasons which have been advanced for this. It is felt, for example, that because the judge has to give a written judgment and to be clear as to the reasons for his or her verdict, it places a greater burden upon the judge to really ensure that his or her reasons for finding someone guilty or innocent are well documented. In some instances, it has resulted in a shorter trial period for some cases, while in other jurisdictions, the research shows that there is a backlog of cases. One of the reasons given is not having a sufficiency of judges to be able to deal with the number of cases, or even in some cases having the physical space to be able to do so. In tempering my thoughts, Madam Deputy Speaker, I still would have preferred to some extent for there to be some leeway for one to be able to appeal the decision of the judge when deciding or when a decision is given as to whether or not to grant the judge alone trial. This particular legislation, as I pointed out, it doesn't provide for that. And I do believe that that perhaps is something that some further thought and some further consideration can be given to. whether it is you go before the magistrate court or before the high court, that is a right that you have in terms of making an appeal relative to the decision that has been granted, whether by the magistrate or the judge. In this particular case, you have no appeal until the substantive case has been heard, and then you are able to make that appeal before the court. So relative to that particular aspect of it, it is still something that, in my view, ought to change. I do believe that if I am accused of a particular crime, and whether it is myself or the prosecution who goes before the judge and asks for a judge alone trial to be handed down, that I should have some right to appeal the decision of the judge. So while this may help in some instances, for me, it removes that aspect, that right, which traditionally we have within our justice system. We are here, and I do believe that there is still the opportunity during committee stage to make that particular amendment. Perhaps in his wrap-up, the Attorney General might suggest the reasons as to why it is that one doesn't have the right to appeal at this particular stage. But again, as I said, that has been sort of a foundation. It has been grounded within our legal system. And for some reason, when it comes to trial alone by a single judge, that this particular right has been taken away. As I said, and I repeat, I do not agree with it, just as I didn't agree with the fact that prior to the amendment being made today, that only the prosecution was able to make an application for a trial to be heard by a single judge rather than being heard by a jury of his or her peers. Of course, there are those who still have that reservation because the jury system, one looks at being able to go to the court, having persons considered to be your peers, being able to find you whether it is innocent or guilty. Of course, in small societies, one has certain reservations also about that. You have the proliferation of the media. The jury can have biases, and when it comes to a decision by the jury, one really doesn't know what was the particular thinking coming from members of the jury as to why they would have arrived at a particular decision. In this case, as I said, the judge has a mandate to document the reasons given. And so in terms of any biases, I suppose that a judge has to be extremely careful in guarding against any of those particular biases. I will end by saying, Madam Deputy Speaker, that to a large extent, the jury is still out as to the effectiveness of this particular piece of legislation here in St. Kitts and Nevis, because throughout other jurisdictions which have been able to utilize it for quite some time, one is able to go and see research as to the results of it. May it please you, Madam Deputy Speaker.
Thank you. Thank you, Honourable Member for St. Christopher 5. I recognize the Honourable Attorney General to do his wrap-up.
May it please you, Madam Deputy Speaker, I rise to wrap up the debate on the bill shortly titled Judge Alone Trials Amendment Bill 2025. and to start by directly addressing what has been referenced by the member for St. Christopher 5. In our Eastern Caribbean Supreme Court Act, there is provision in section 33.3a. The reason I know it so particularly because I argued it in the Court of Appeal last year. That is a section that says orders in a criminal cause or matter cannot be appealed. And let me explain the reason for that, Madam Deputy Speaker. Because a criminal trial is so dynamic, there are lots of decisions that are made by judges and magistrates after charge. So the police, they prefer the charge. You go before a magistrate, originally, typically, and certain orders are made and decisions are made as to the process going up to the High Court trial. And even in the High Court trial, the judge makes numerous decisions. So the court decided in 1975 that any order or decision that is of a criminal nature within the proceedings, similarly termed interlocutory, are not appealable. So we actually, there's an appeal to the Privy Council being made by someone in St. Kitts and Nevis in the matter that I'm in, challenging that. But we will deal with that in the Privy Council. The court has said that is reasonable. The Court of Appeal has said it is reasonable. Previous Privy Council decisions have said it is reasonable because what the result of having numerous appeals would be is that what you're trying to prevent, which is to get swift access to justice, could actually be affected if there's an appeal on every single decision that's done in the process. So imagine, Madam Deputy Speaker, there was an appeal of the decision to move the matter to the High Court. You would have to wait a year, 2 years on the decision of that appeal, and then come back to the magistrate for the magistrate to then move it to the High Court. Imagine there was a decision of a judge preliminary to trial saying that this witness is not needed, for example. There would be an appeal, you would have to stay the trial for another year, 2 years, and then now you've added 4 years to the time before you actually get to trial. So the reason why that provision of the Eastern Caribbean Supreme Court Act is there is to prevent numerous appeals in one criminal action, get to the end, and then appeal everything at that point. And what is considered in the Judge Alone Trials Amendment Bill is that there is no appeal for the decision of the judge to treat it as a judge alone, because that is considered an interlocutory order of the judge. So it aligns with what the Eastern Caribbean Supreme Court Act says. Matters of this nature, if they were allowed to be appealed, would then delay justice. Whereas when the matter is delivered, you can appeal and say, for example, this matter should have never been judge alone. I was prejudiced in some way. And the Court of Appeal can then strike down the entire judgment, and then the process could start over. But it's to eliminate the interlocutory appeals and the process being slowed down while it is moving through the criminal justice system. So I hope that is an explanation that the member can understand and also reflect to the persons he represents, given the position that he has taken, which is not wholly unreasonable. It is a good question, and it gave me an opportunity to explain why that aspect of trial, interlocutory matters that are done within criminal trials, are not generally appealable in the Eastern Caribbean Supreme Court. And then this type of interlocutory order is also not appealable. Madam Speaker, judge alone trials, as I gave the example of the UK, the UK's recent report, are one of the pathways to having an efficient justice system. And we, as an administration, listen. We're not bullies. We don't believe we know everything. And what we're doing is trying to do things that are in the best interest of all of the people of St. Kitts and Nevis. And after the original act was passed, even though it was sent for consultation before, that point was raised. Shouldn't the accused have an opportunity to apply for judge alone? It would be very rare because of the reasons that are typically, the reasons that govern why there is a judge alone trial. For example, pre-trial publicity, persons are involved in gang activity. Those are matters typically for the prosecution. But you can see there might be some some small group of reasons why an accused themselves would want to have a judge alone trial rather than a jury trial. For example, if they thought their case was particularly complex and a juror would not be able to understand, then they could say, I prefer a judge who understands the nuances of certain evidence to give the judgment. It could also be that some of the evidence they wish to present in their defense is of a particular nature that a jury might not be appropriate. So that is why we came back and we sought to amend the Section 5 to allow for not only the prosecution to apply for a judge alone trial, but for the accused to have that opportunity. We believe, Madam Deputy Speaker, that this short amendment accomplishes what we want to accomplish, which is to create a fair system and so that to fit within an efficient justice system, so that anybody in St. Kitts and Nevis who interacts with the justice system doesn't feel that they are being treated unfairly, that justice is done, that their constitutional rights are protected, and we reach the point where we get from charge to completion of matters within that 18-month window which we have all agreed we wish to go to in the Commonwealth Caribbean. And this is one of the steps in that process. So with that said, Madam Deputy Speaker, I wish the bill safe passage through committee stage. May it please you.
Thank you, Honorable Attorney General. The question is that the bill entitled Judge Alone Trials Amendment Bill 2025 be read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill to amend the Judge Alone Trials Act, number 20 of 2024, otherwise known as the Judge Alone Trials Amendment Bill 2025.
The bill entitled Judge Alone Trials Amendment Bill 2025 has been read a second time. House moves to committee stage.
Clauses 1 through 5.
The question is that clauses 1 to 5 stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
The enacting clause.
The question is that the enacting clause stands part of the bill. Those in favor? Aye. Those against? The ayes have it.
The title.
The question is that the title stands part of the bill. Those in favor? Aye. Those against? The ayes have it. House resumes. I recognize the Honorable Attorney General.
Madam Deputy Speaker, I rise to report that the bill shortly titled Judge Alone Trials Amendment Bill 2025 has safely passed through committee stage without amendment, and I beg your leave for it to be read a third time and passed into law.
Seconder, I recognize the Honorable Member for St. Christopher 3.
Madam Deputy Speaker, I rise to second the motion.
Thank you. The question is that the bill entitled Judge Alone Trials Amendment Bill 2025 be read a third time and passed into law. Those in favor? Aye. Those against? The ayes have it.
A bill to amend the Judge Alone Trials Act, number 20 of 2024, otherwise known as the Judge Alone Trials Amendment Bill 2025.
The bill entitled Judge Alone Trials Amendment Bill 2025 has been read a third time and passed into law. Next item on the order paper.
Motions, resolutions, adjournment.
I recognize the Honorable Member for St. Christopher 1.
Madam Deputy, I rise on the adjournment at this time just to share some information. I slipped out a few minutes ago, and I was engaged with some young persons who are here on a camp at the agricultural conference room, where we are celebrating 35 years with UNICEF. And of course, you know, on the signing of the ratification of the Convention on the Rights of the Child by our federation, and I was happy to spend a few minutes with them while I rushed back. And on the adjournment, I just wanted to express my sincere gratitude as a minister with responsibility for social development alongside the Honorable Iseline Phillip, to publicly thank UNICEF for the work that they have been doing and the support they have given to this federation over this long period of time. There are quite a number of accomplishments that we would have been able to do or get done because of their significant, not only financial, but their technical support, and we look forward to their continued support. So I just wanted to express my gratitude and thanks to P.S. Clark and her team and the whole team that's there from UNICEF. Additionally, Madam Deputy Speaker, I thought it was important for me as a parliamentary representative in support of the Honorable Congress Maynard, who made presentation in this Honorable House last, making reference to the work that is being done on the George Street Road. I recognize and I realize that the road continues to be talked about, not always in the positive, but I'm happy to report that a road that would have been neglected for decades have been going under comprehensive renovations, and this was explained, Madam Deputy, to the entire community since in May. And we have completed the pipe replacements, and I went there 2 days ago again expressing my I'd nearly say sympathies, but of course my apologies to the residents there, asking them to be a little bit more patient because we are going to deliver a first-class road. Because sometimes when you start work, you don't know what's under there, and we had a similar case on Southwell Drive. So I just want to express my thanks to the Honorable Congress Maynard and the Public Works team for the work that they continue to do in allowing us to be able to deliver the George Street Road, Madam Deputy. The drain, they had to redesign the drain because the drains that were there for maybe my lifetime no longer would have been able to match with the quality of resurfacing that would be laid, and they are doing that work. Right after that, they are going to be putting down the asphalt, the packing and the asphalt. Again, to the residents on George Street, Newtown, I ask for your patience. I apologize for the dust, which is part of construction, regardless of what you're doing. And I ask you to bear with us as we deliver. Because you see, Madam Deputy, it is important for me to speak this way. Because there are some persons who seem as if their only way they are set out is to be negative. And we are making sure that we deliver. I am making sure that we deliver. Because when some persons give the impression that they are so concerned about a particular area, if that was the case, Madam Deputy, when the Honorable Congress Maynard parliamentary representative for number 3 was up in their area to give them a road where only 2 homes are there, I would have asked them to go and fix George Street. I am delivering George Street. May it please you, Madam Deputy.
Thank you, Honourable Member for St. Christopher 1. I recognize the Honourable Member for St. Christopher 4.
Madam Deputy Speaker, with your leave, I rise on the matter of adjournment just to briefly speak about this weekend's activity as it relates to West Indies versus Australia here in sweet sugar city, St. Kitts and Nevis. Madam Deputy Speaker, we are seeing the end of the tour, but what we are seeing here is the T20 series, the last 3 games here in St. Kitts and Nevis, played at our historic Warner Park. We see the games tomorrow evening at 7, Saturday evening at 7, and as well as Monday evening also at 7. So I want to take this time to invite our nation out to Warner Park to enjoy lovely cricket. Lovely cricket. Australia has come quite a ways here to the West Indies, and they're here on our lovely shores to play beautiful cricket here in St. Kitts. So, Madam Deputy Speaker, I'd like for all to join with me and welcome every single citizen in St. Kitts and Nevis out to Warner Park to enjoy West Indies versus Australia, the T20 games, Friday night, 7 p.m., Saturday night, 7 p.m., and Monday night, 7 p.m., because we home. We home here, St. Kitts.
Thank you, Honourable Member for St. Christopher 4. I recognize the Honourable Member for St. Christopher 3.
Thank you, Madam Deputy Speaker. On the occasion of the adjournment, I want to mention, of course, that next week starts our ICON Roots and Culture Children Summer Camp at the Dr. William Connor Primary School from Monday to Friday from 9 to 12 in the morning. And that has lunch, your T-shirt, and all the things you can learn about roots and culture from our heritage. So I think registration is already full, so just encouraging those who would have registered to come out and have an excellent week. And I want to thank the organizing team for the excellent work that they're doing, and all of the participants and the stakeholders who will be teaching our children to sew, to cook, to drum, to dance masquerade, to braid, all of those things that are unique to us. I want to thank also the member for number 1 for, acknowledging the tremendous amount of work that is being done in the George Street area, and I too want to ask the residents of the area to bear with us a bit longer. If you notice, we have paved a number of streets since then, but that is because we only had to resurface those. So member from number 5 would notice that after a very long time, there are some brand new roads that are in Sandy Point, and I want to commend the ambassador for sports, Mr. Kenneth Douglas, for his unwavering commitment to pushing us to do that, and so we are continue to do that. The situation in George Street is that, of course, we had major infrastructure advancements to do. Water Services Department announced to me or informed me that they now finished their work in terms of laying all of the underground pipes. This is to minimize the need for when the road is paved that we have to go and dig it up again. Now, I'm not saying it won't happen, because you can always miss something, and then when you roll roads, you can also disturb pipes in the process. So we've tried very hard to not have to go back, and I think they're doing the drainage now, and as soon as that is finished, they're going to lay the road. George Street is a critical artery, actually, in the whole of St. Kitts and Nevis. Everybody knows where George Street is and how it links Bastia to outside of Bastia. And yes, the member from number 1 is right that in other areas of this country we are doing significant roads, including where some of the persons who are questioning George Street presently reside. In fact, I had informed them that we would not discriminate against where they live and ensure that the brand new roads in Shadwell West and Shadwell South, that persons like them would not be left out. And it is true, they did not tell me wait and go and finish George Street, but you know, we understand that we are to be providing roads for everybody. And so I want to thank the member for that. We are serving the entire country, none is left out, whether it's West Bastia, Central Bastia, East Bastia, constituency number 4, constituency number 5, number 6, number 7, number 8. We are doing road rehabilitation in every single constituency around the country. And so thank you, member, for bringing that to our attention, and we will continue to do that. With that said, Madam Deputy Speaker, I want to concur with my colleague, member from number 4, in inviting everybody out to a weekend of extraordinary cricket. We have, obviously, one of the giants of cricket here in St. Kitts and Nevis. I also want to take this opportunity to commend the extraordinary work of the people of St. Kitts and Nevis. Many doubted that it was possible for us to have 2 major events at one facility in a matter of weeks. Many doubted that. And I want to thank the Ministry of Tourism, led by the Minister and representative from constituency number 2 and her team. In fact, I can think of one Mr. Bridgewater, Loftus, who spared no effort. I think he lost sleep and all to ensure that St. Kitts and Nevis shows the world that we are capable of hosting the biggest ever music festival at the Warner Park Stadium, prepare the ground to host the biggest cricket matches in the Caribbean, and do it in style. If you're going to take a look at Warner Park now, and we still have a few more weeks to go, yes, you will not believe. I want to thank the groundsmen for the work that they're doing, and it shows that once we put our minds to something, we make sure that the resources are available, and your plan, you can execute. It is in this very house, I mentioned that across the globe, it is a traditional model, it is an established model that sports facilities are multi-purpose facilities. That if you plan properly, you can have both sporting events and you can have large concerts. But you just have to plan properly. Instead of sometimes thinking that you need one facility for something, another facility for something, with the limited resources that we have. Absolutely, Madison Square Gardens, but any facility, Hazley Crawford in Trinidad, for instance. And what we have to do is to manage them properly and make sure that we plan effectively. And so I want to commend all who are involved in that, from the Ministry of Sports, Ministry of Tourism, the groundmen who are taking tremendous pride in what they're doing, and we want to congratulate them because we're in for an excellent showing come this weekend. So I want to invite everybody to the cricket matches come this weekend, I think Friday, Saturday, and Monday evening at 7 p.m. With that, Madam Deputy Speaker, I now move a motion to have this House adjourned sine die.
Seconder, I recognize the Honourable Member for St. Christopher 1.
I second that motion, Madam Deputy.
The question is that this Honourable House stands adjourned sine die. Those in favour? Aye. Those against? The ayes have it. This Honourable House stands adjourned.
If you haven't done it as yet, please do it today. Subscribe to our YouTube page at SKNIS Media for regular updates, live coverage, and even more information on your government. While you're at it, like, share, and interact with our Facebook and Instagram pages at SKNIS Media and SKNIS Info.
Greetings, I'm here with Ambassador Kenneth Douglas in the Berks Sandy Point area, doing one of the projects that are listed on our resurfacing campaign in Public Works. I want to take this opportunity to thank the Ambassador for bringing these community roads to our attention. Sometimes when you're driving on the main roads and so on, even staff, they won't necessarily know all of the roads, so it takes community leaders like Kenny and others to indicate where there are some challenges in our road network. So I want to thank you for that. You have been a strong proponent. You haven't been giving me any rest, which is fine, and I gave the community